All right, ladies and gentlemen, we are fortunate to be joined right now by Jay Sekulow, Chief Counsel for the American Center for Law and Justice and author of Undemocratic, Rogue, Reckless, and Renegade. Hello, Jay.
Hey, Steve, good to see you.
Good to talk to you. Good to see you. All right, lots to get to. Let me ask you your opinion as a man in your position. I'm no attorney, so let me go to you. Corey Lewandowski, based on what you've seen on the tape, now we find out also that the prosecutor that charged him is a member of this pro-Hillary group down there in Florida. What's your take on the charges, and did he break the law?
Well, look, if he did, you have to have to commit a crime, even a misdemeanor, you have to have an intent to do it. And when I look at the tape, it's question, you can't judge intent by a tape, but it certainly doesn't look like anything other than he was trying to get this reporter away from the candidate. Now, a simple battery charge is a misdemeanor, and that's not a hard element of proof to show. But I will tell you two things. One, Steve, it's not going to trial. There's not going to be a trial on this. This is a misdemeanor. It's going to be probably pled out. He doesn't have any priors, so I don't expect anything significant there. And it's a question of, did he have the intent to cause a crime, the crime of battery? And I think that, is not easy for the prosecutor to prove. He may have committed a battery. I mean, that's going to be for a jury to decide, but it's not going to ever be decided by a jury. It's not going to trial. I think this is a distraction at this point, quite frankly.
All right. Well, I'm glad to hear you say that, because I couldn't agree with you more from a layman's point of view.
It's a tussle of a political campaign when you've got the candidate surrounded by 100 people, and he saw something he was concerned with, and he made a move. I mean, so that doesn't mean, again, they got to prove criminality. Could it be criminal? Yeah, but you got to establish that beyond a reasonable doubt there has to be criminal intent. It's a pretty tough case.
All right, let's move to Hillary, who we've learned, we're learning more and more. Another judge weighed in on the Judicial Watch case, very upset with the State Department and ruling against Hillary in that matter, combined with the pending, we believe, FBI questioning of at least her inner circle, if not herself. As we find out more and more, and emails revealing that why she set up the server and how she set it up was in conflict with what she said now under oath to Congress. I mean, how serious with 175 FBI agents? What do you see happening here?
I call it the FBI primary. I think this is something that's significant. I was a government lawyer myself in the Office of Chief Counsel for Treasury. The IRS was my client. And I did these cases where you did what's called a CRL, a criminal reference letter, where you evaluate the agent's reports. You look at those reports, you look at the evidence, and you put together a case, send it over to the Department of Justice. And when you send it over to the Department of Justice, it's with the recommendation of a criminal prosecution. I think it's in the CRL stage. We don't know if she's named individually, of course. We don't know if they've even done that. But I think it's in that stage. But I don't think the final tale has been written on this. And I think this can be a significant issue for Hillary Clinton. I suspect that's why Bernie Sanders is saying in this. I mean, mathematically, he doesn't have much of a chance, but if she goes, he does. Yeah. So I think final tale has not been told on this one.
All right. Interesting. The Supreme Court, we're seeing the effects now of the 4-on-4 against 4, the death, the tragic death of Antonin Scalia, the case with the unions that goes, the lower court stands, but it's not a precedent, and it could be taken up again when the court has its 9th member. Correct?
Yes, but it was interesting in that case. It would have been 5-4 with Scalia in the majority, and you would not have been compelled to join the unions. But let me take it a step further. The Little Sisters of the Poor case got a very unusual, but I think helpful order yesterday for those that are concerned about religious liberty. That is the HHS mandate being applied to the Little Sisters of the Poor and some of these other Christian and nonprofit organizations. The court basically said there's got to be another way to handle this, issued an order requiring additional briefing. I think this is a very good sign for those of us that view this as a significant religious liberty issue. So I think there's some progress on that front.
Good. Glad to hear that. Jay, go ahead. Yeah. No, we only got 10 seconds. Go ahead.
No, even with the 4-4 tie, I think it's still a positive.
Great. Jay, great to talk to you, sir. Thank you very much.
Appreciate it.
Jay Sekulow, ladies and gentlemen. Up next, Noah Rothman and Adam Thompson on the Malzberg panel. Don't go away.